Welcome. This is James Corbett of the Corbett Report with your EyeOpener Report for BoilingFrogsPost.com. The Freedom of Information Act is intended to be one of the American citizens' key checks against the fraud and corruption that inevitably happens in the corridors of power when information can be hidden behind a secrecy classification. Originally enacted in 1966, it has been used to bring to light a number of startling documents over the years, from internal memoranda on the Bush administration torture program, to contracts exposing how Homeland Security is using social media to monitor lawful political dissent, to financial records detailing the ties of Federal Reserve presidents to the corporate world. One agency of the government that has been notoriously uncooperative with the spirit and the letter of the FOIA law, however, is the FBI. Since the days of J. Edgar Hoover, the Bureau has zealously guarded some of its key documents and acted to stonewall those seeking access to sensitive records, which are said to include scandalous details of some of the highest-ranking political figures of the past century and explosive details of some of the Bureau's biggest investigations. Last year on the EyeOpener, we examined some of the methods that the FBI has used over the years to protect key documents from Freedom of Information requests. In that report, we detailed how the Bureau keeps separate files and storage spaces for case notes where problematic documents can be inserted to stop them from showing up on FOIA-related requests. Using different names like June files, Zero files, S drive, and iDrive, these files can be used to collect all of the data and documents related to an investigation before the final official file is created. As we detailed at the time, if the Bureau did not want a particular document to show up in a FOIA search of their records, all they would have to do is to make sure that it did not end up being transferred from the temporary storage to the final case file. Now, yet another method of circumventing FOIA requests has been uncovered. Last month, Jason Leopold of truthout.org detailed the story of Trevor Griffey, the co-founder and project coordinator of the Seattle Civil Rights and Labor History Project. In the course of his research for the project, Griffey filed a FOIA request to discover if Manning Marble, the founder of the Institute for Research in African American Studies, had ever filed a FOIA request for Malcolm X's FBI files. Puzzled by a response suggesting the FBI could not identify any such documents in their main file records, Griffey contacted an FBI FOIA analyst who admitted that a file responsive to his request had in fact been blackballed as part of the Bureau's standard operating procedure. Filing a FOIA request for more information about the blackballing process itself, Griffey managed to obtain part of an internal PowerPoint presentation revealing key details of the blackballing procedure. Blackballed files are files that are initially pulled up as being responsive to a Freedom of Information request, but which an analyst deems to be not pertinent to the original request. When that file is blackballed, even the fact that it was pulled up at all is not reported to the FOIA requester. Leopold cites Arlington, Virginia-based attorney Kel McClanahan as saying that he has seen the FBI blackball records because they weren't FBI records, even though they were in FBI files. I've seen it blackball records because the request asked for internal FBI records, and the records in question were sent outside of the FBI, based on a strained interpretation of the word internal. As disturbing as this new finding is, there is also a potential remedy. Ironically enough, when information has been blackballed, that process itself can be discovered under its own separate Freedom of Information request. Jason Leopold appeared on Corbett Report Radio last month to explain.
Let's say you also file a FOIA request on George Bush, and you want some documents, and they say that they don't have any responsive files. But behind the scenes, they actually found some files, but for whatever reason, they are blackballing it. And again, perhaps it's not the exact file that that you need, because there are what you sought was not contained in that file, and there may be another reason. So when Trevor had asked for this standard operating procedure, he filed a FOIA request for it, and he received the FBI standard operating procedure for how it blackballs files. And there are several classifications. So 190 main files. 190 main files is a classification that the FBI uses for Freedom of Information Act and Privacy Act requests pertaining to individuals. There's a classification for civil litigation. That's 197 files. And then there's an entirely separate classification that the public does not know about, that we have no idea why the files would be ripe for blackballing in that category. They actually redacted that information in the standard operating procedure. So unless you are a savvy FOIA requester and you know how FOIA works, you will never know that the FBI ever blocked these files, blackballed them from being released. You will never know why. You will never know what the what the purpose was, unless you make another filing for what are called processing notes. And basically, what processing notes are, it provides information to the requester about how the FBI, or any other government agency, by the way, I don't want to just limit it to the FBI, how they would respond to a FOIA request.
While this information is potentially empowering to those who receive a no responsive records notice to a FOIA request, the entire process of blackballing raises a troubling question about the nature of governmental secrecy itself. Government secrecy by its very nature relies on a trust that not only those currently in charge of the system will not abuse the public trust, but that no conceivable group in the future will ever use the cloak of secrecy to hide government abuses and corruption. Now, after the American public has been lied to again and again, through decade after decade, about Pearl Harbor and the Gulf of Tonkin, about Iran-Contra and Saddam's WMDs, about torture and warrantless wiretapping, about 9/11 and the War on Terror, how could it any longer be a hypothetical question whether those in positions of authority have abused that trust? And given that selfsame history, if government agencies are once again finding new tricks and loopholes to hide information from the public that they are ostensibly there to serve, how can the system of governmental secrecy, institutionalized and whitewashed by the Freedom of Information Act, be justified at all? This video is brought to you by the subscribers of BoilingFrogsPost.com. For more information on this and other topics, please go to BoilingFrogsPost.com. For more information and commentary from James Corbett, please go to CorbettReport.com.